as there is before. And I sent instructions sometime between 1:30 and 2 this morning. And lest the rumors start that Schroeder can't sleep at night, I sleep in shifts, which is actually the normal way to sleep. And I fell asleep during the Blackhawks game, which I shouldn't have. And then I awakened and did my work, and then I went back to sleep. What's going on with those instructions?
Judge, if I could, initially I was hoping that the court would take up our motion for reconsideration, which was filed a week ago Monday.
Right.
And once that's done, depending on how you rule on it, I would have an objection to 2176 because in my reading of 2176, the notes set forth what is to happen or how the court is to do it when there is an alleged exception, which we are alleging here. And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And the response is that I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week. Didn't mean you didn't file it. I mean, I didn't get it, and I didn't have a chance to. I looked at it somewhat, but not all of it. And there was one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation or the forfeiture action alone, and I can just tell them I'll instruct them on everything at the end of the case. How do you feel about that?
Judge, I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. If it's not the subject for a motion to dismiss, the complaint need not deflect or address every single affirmative defense. And this, so I believe there's no basis to challenge the complaint to actually get the complaint dismissed. If they wish to present a case, if they wish to raise an affirmative defense, which is that he was compliant under both of those subsections, that if he had a hunter safety permit or the certificate of completion that the second part of that, third part of that statute calls for, they can do so. But until they do that, I don't see why that should be in the jury instruction. We don't have the self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly will attempt to do so, then it can be in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not want to. I did not want to be untimely, but that does lay out why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of the curfew violation, we're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
You don't think I can just take a 12-person jury to decide it?
Well, it's a different standard of proof.
Well, that
confusing. Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause, we've met our standard in the complaint, and it's been bound over. And now it's up to the defense if they want to try and raise this affirmative defense. We disagree that being 17 in and of itself raises an affirmative defense. The state believes he'd have to present the certificate of completion of a hunter safety permit as called for in the statute. Thank you.
Okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those. Well, I don't know if then that's probably not the best thing to do either, because then they don't know what we're talking about. What's your reaction to the claim that it's an affirmative defense?
It's not an affirmative defense. For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court through the legislative history makes it clear it's an exception. It's not an affirmative defense. It is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in 3 different places it tells you in plain language that it does not apply. Not for hunting purposes, it does not apply, period, to 16 and 17-year-olds who possess firearms. That is, and I provided that to the court both in the Act and in the Senate Bill, Judge, and in the Legislative Reference Bureau information.
Well, I'm going to give the instruction as I've stated it. These are educational. They don't get a written copy, and they're just so they know what we're talking about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, assuming that the motion is denied, which you shouldn't assume. But if the motion is denied, then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think. I don't want to leave them uninstructed on the one hand, and I don't want to misinstruct them on the other, but no matter what it is exceptional from the general language of the statute.
Hey, Judge, I'm not going to argue with you about it. It makes it a strict liability offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
No, unless he has the
No.
safety certificate. That's the last part of the statute. In Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17...
That's how you read it.
Right, not how we
He reads it differently.
That's how the DNR reads it. And that's how they cite it.
Yeah, okay.
So in
All
16
right.
and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
Yeah, well.
And that's being completely ignored in Mr. Trofsky's argument.
Okay. I am going to give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay. And the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
Yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't I have a general instruction on self-defense?
You listed him specifically for the charges or for the counts?
I did?
That's what I saw.
Boy, it was early this morning. It says counts 1 through 5. Oh, no, that's not it. You're right. Let's see, count 5 is attempt to commit murder. That is going to have the same self-instruction same self-defense instruction as count. One, 3, and 4.
Very good. I just wanted to make sure that.
You were correct in your observation.
Well, you tell me when you're ready, Judge.
Okay, what else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. McGinnis. Count 2? Count 2, I'm sorry, 820. Jury instruction 820 is mentioned in there. Mm-hmm. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph, the last sentence says the defendant does not have a privilege of self-defense as to Richie McGinnis. I don't know if you see that. However, later on in the instruction, it says if the defendant was acting in lawful self-defense, his conduct does not create an unreasonable risk to another. So I guess the concern I have is one portion says he doesn't have a privilege of self-defense. Then another portion of that same instruction says he does have the privilege.
I stumbled over the same language. Yeah. And what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee, was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the jury to consider in determining whether his conduct was criminally reckless, and also was a factor for them to consider in determining whether it was done with utter disregard for human life. That's how I read it. I certainly don't think I would want to get, you could put a law school test together on this, but that's how I read it. Now tell me where you think I'm in error.
Well, I'm not saying you're in error. I'm saying if he's in self-defense as it relates to Mr. Rosenbaum, according to 820,
I think this is how I reconciled that reading in my mind was that when the jury decides about the charges involving the 4 children, the jury is to consider whether I was acting in self-defense with respect to the bad actor. That's a consideration in determining whether my conduct was reckless with respect to those children. and also whether it was, showed utter disregard for human life. And the jury might reconcile that by saying, well, you should have tried to change positions so that your shot wouldn't have the children in the background. That's how I reconciled it. But I agree with you, it's confusing.
Because I read 820 to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says. So I don't think then.
Well, why do they? I'm sorry. Go ahead.
No. So I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by that fact, according to 820. The instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And then there's a period. So.
Well, why does it say up above that the, in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful.
I agree. That's what I said to you.
No, what you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schroeder to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't, you're telling me there's an absolute privilege of self-defense, not only as to the bad actor, but also as to the children.
Only if, according to 820, only if the conduct against the bad actor was self-defense. That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another. Period.
If you look at the comments from the instructions committee, on page, well, I don't know if you've got the pages there, but well, I have them, but near the end it says, for example, assume that a defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is there is not what you're arguing, I think, becomes a perfect self-defense as to injury to others during the exercise of perfect self-defense, and I don't think that's the law. It maybe was what we once thought, but I don't think it's the law now, and that the jury, when they approach the McGinnis case, looks at whether the defendant, even if exercising perfect self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. McGinnis's endangerment, but instead the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considers is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the count involving Mr. McGinnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was, if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis. That's how I read it, and that's how I'm going to say it. But I'm going to try to skirt around those 5th, 6th, and 7th counts because we don't have an instruction for number 7 and number 6 is. I've had lots of statutory issues come up over the years, and this is the knottiest. Okay. Other than that, any problem with the instructions?
Nothing, nothing else from me, Jim.
State?
No.
Okay. Let's get the jury down.
Your Honor,
Before you do that,
Your Honor, I do want to put something on the record with regard to the jury.
Oh, yeah, I got something here, too. Yeah, what's up?
Your Honor, at the end of the proceedings last night, Brian Stute from our office came in to begin the process of setting up the audiovisual equipment and whatnot. While he was, I think, entering the courtroom from the hallway, he passed by one of our jurors, and I'm going to identify this juror as juror 52. I can say more about that person's identity, but I don't want to do it openly in court. My understanding is that juror 52 recognized Mr. Stute, said something like, hey, how you doing? Like they knew each other, and I think Mr. Stute responded, politely in response, and that was the extent of their interaction. Mr. Stute has explained subsequently that he had a previous employment where he remembers juror 52 from, and so that's the extent of their prior knowledge of one another. So I wanted to lay that on the record so that everybody is aware of that. I did tell counsel about that this morning before we went on the record as well.
All right. Any question or observation?
Judge, do you feel the need to ask her if that would have any impact on her ability to serve?
I don't. You can ask you can ask me to ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have a question about the accuracy of the report to me. I think it's a non-issue.
That's fine, Judge. We are ready to go forward.
Splendid. Okay, anything else? And I did get a note Do you know from whom this came? Well, I don't know which one though.
She didn't put a turn number on there?
Yeah, thanks.
You know you have the kill switch.
Does this only suppress the sound while I hold it down, or does it click on and off? Press. And then if I put, and now I'm live again, right? Okay, I've got the nice hand signals here from the respectful hand signals from the Court TV crowd. Thank you.
It's on the back.
I agree with your observation. Okay, you know what? Give them to the. It all makes sense once you.
I'm guessing.
Okay, well, I guess too, but. Okay, let's ask the lawyers to come up, please. Huh? What did he say?
Sure.
Okay. Make a copy of both sides and then pick it back up, please. All right. I'll wait long enough for that to happen. You know what? She can. You can give it to her when she comes down. All right.
Hello,
Would you come down, please?
you got it.
Thank you.
Bye.
We need the door open. I don't know if somebody's standing over there or not.
One to a chair, please.
No, we're not using those. We're just using this area. One person can still sit up there. And then push that chair back. Yep.
Oh, okay, good. Thank you very much. Well, give one each side. Okay, there we are. Oh, wait a minute. My response isn't on there. Is my response on the ones you've got there? No. Okay. Give each side, if you can hunt it down, the photocopy of with my response. Make a copy for each side, and then we'll take care of it. You can be seated. Good morning, everyone.
This one, the gentleman with the scooter.
Okay, and then we have to swear the jury.
Yep.
All right. Maybe you can. building is almost 100 years old. We're going to have our 100th anniversary, I think, the year after next. And then the chair is original equipment and some of the furniture here. And then can you move that, which is the most comfortable location? Would it be comfortable down there? Right there in front of the officer there?
We'll
Well-
just have to move the chair.
Yeah, well, that might, will he be able to see everything from there? That's my only concern.
Your Honor,
Okay, yeah,
both sides want to put the TV right in front,
okay, perfect.
so, okay.
All right, great. I'll talk more about the building later. And that chair, when there's a break, we're going to move that out of there because I don't think I like it there. Yeah. Did you fill in the sandwich? I did. And I gave it to Tammy. Thank you. And that can go to the. Thank you. And then one of these. Okay, one of those to each side when there's a break or something. Good morning, everyone, and I'm glad I told you not to come in until 9:45. I did tell you that, didn't I? Oh, okay. All right. No, we were doing some legal stuff, and that happens periodically throughout the trial, and it's nothing exceptional. In fact, it usually ends up saving some time, some of your valuable time, and so we hope Oh, I see how it's laid out. Okay, we hope won't have too much more of that today. Would you? We're going to swear you now your oath to reach a fair and just verdict. So, if you would please,
Can I
Mrs.
ask all
Lehman.
the jurors to raise their hand, please, to take the second oath? Do you and each of you swear that you'll well and truly try the issue joined between the state of Wisconsin plaintiff and Kyle Rittenhouse defendant, and unless discharged by the court, a true verdict give according to the evidence given in court, so help you God?
And please silence those phones if you would, if you've got them on an audible signal. And before the trial begins, I want to give you some instructions which I hope will help you better understand your functions as jurors and how you should conduct yourselves during the trial. Your duty will be to decide the case solely as the evidence develops, presented at the trial, and the law is given to you in my instructions. Anything that you see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, age, or politics affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all of the evidence has been presented and I have instructed you regarding our law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. There are times when I need to discuss legal matters with the attorneys that do not necessarily concern you, or in some cases, it's something needs to be discussed outside your presence, and you'll be excused at that time. Usually, if it's going to be short, I'll just put you into the conference room back here, it might be a little bit tight, but I think you'll be okay. And otherwise, we may take a break, and you'll be up in your jury room. When you're in the jury room, you need to stay there. You can't be wandering the hallways. You can't be coming and going, except when you have permission from the bailiffs. And you do have, if you have permission from the bailiffs, you may go to the break room across the hall here, where they've got some vending machines. And you can also go outside if you want to get a little fresh air, or smoke if that's what you want to do. The bailiffs will escort you, so you need to go as a group, and they know the procedure, and then go back directly to the jury room and remain in the jury room until you're dismissed for the day. Do not research any information that you personally think might be helpful to you in understanding the issues which are presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about the trial. Do not consult dictionaries, computers, websites, or other reference material for additional information. Do not seek information regarding the public records of anyone involved in this case. Any information that you may obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experiences as jurors while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so. This case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on the jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial has been completed, you are free to communicate with anyone in any manner. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has reason to believe that another juror has violated these rules, you should report that to me. You are to decide this case solely on the evidence offered and received at this trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which are received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I am not indicating any opinion about the value of that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. The bailiffs will supply you with the materials. You may rely upon, after the trial, your notes will be collected and they will be destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily upon your memory of the evidence and the testimony introduced during the trial. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice, if any is shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant the third element is that the circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male, and to each of these charges as well the defendant has pleaded not guilty. Reckless endangerment of the first degree, as charged in these counts, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree as to either of these counts, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. A great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger of the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other circumstances relating to the conduct. The fourth count of the information charges that at the same time and place the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. You cannot look into a person's mind to determine intent, which must be found, if it is to be found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be Intent should not be confused with motive. While proof of motive is necessary to a conviction, While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first degree. The crime of attempted intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first-degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have committed that crime except for the intervention of some other person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following two elements of this crime were present. First, that the defendant intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Again, you cannot look into a person's mind to determine intent, which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, and while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The sixth count charges that at the same time and place, the defendant was a person under the age of 18 years and was armed with a dangerous weapon. The seventh count charges that at the same time and place, the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit which was engaged in emergency management activities under Chapter 323 of the statutes. The defendant has also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special circumstances in which emergency management edicts are issued and the requirements which are imposed for obedience to those edicts. The first 5 counts of the information allege not only that the defendant committed the crimes which are charged in those counts, but also that he did so while using a dangerous weapon. If you find the defendant guilty on any of those counts, then you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you can answer the question yes, if you are called upon to answer it, then you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. That is with respect to counts 1, 3, 4, and 5. So those are the charges of reckless endangerment, reckless homicide, and intentional homicide, and attempted intentional homicide. A separate instruction applies to, I misstated that. The instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gage Grosskreutz. There is a different rule applicable to the charge involving Richard McGinnis, the second count, and that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard McGinnis, because Richard McGinnis was not any way acting with aggression towards him. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. McGinnis, who was in the area of the gunfire. And so you have to analyze that separately and determine, well, I'll get further into it. Keep in mind that a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances then existing. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all of the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm as to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Mr. Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. McGinnis showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. We're going to hear the opening statements of the lawyers now. And we follow the procedure where the state speaks first. You know, sometimes you see these actress judges on TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument you're going to have is with me, because there's no such thing as an opening argument. It's opening statement. The argument is for the end, and that's when they're going to make their pleas to you to return verdicts in accordance with their beliefs. At this point, they're going to briefly acquaint you with what they think the evidence is going to show, give you an overview, alert you to the things they especially want you to watch for in the evidence, and they can be very useful to you for those purposes. And they're brief. And then we can right into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf of the state, and then Mr. Richards will have the opportunity to make an opening statement now, or if he prefers, he is entitled to reserve his opening statement to a later point in the trial. And with that, again, no note, well, you haven't got the papers yet anyway, but no note-taking now because this is discussion by the lawyer. But please give them your attention. And with that, Mr. Binger, you may proceed.